Does the ADA apply to every website? Well, the answer to this question has multiple layers from different angles. So let's start off with the law itself. The Americans with Disabilities Act was signed into law in 1990, and it did not contemplate modern digital technology such as websites and mobile apps. So since the inception of this law, there have been no amendments and no subsequent regulation that have addressed this modern digital technology as it pertains to private entities under Title III. And so the DOJ's current stance, and the Department of Justice is the regulatory and enforcement agency behind Title II and Title III of the ADA. The DOJ's stance is that the ADA does apply to websites. However, that's an informal stance. They have not issued actual regulation. And Congress has not amended the Americans with Disabilities Act to contemplate modern digital technology. So there's nothing in the ADA itself that addresses websites and mobile apps. It doesn't say, the ADA doesn't say whether or not it applies to websites and mobile apps, and then it doesn't state how to make that technology accessible and therefore compliant under the ADA. So with private litigation, state and federal courts have varied in how and in whether and how the ADA does apply to modern digital technology. And so in the federal courts, there are 11 circuits where these cases are heard. And in state courts can hear these matters generally. And we have differing opinions. But importantly, plaintiffs' law firms can file in courts that are receptive to their quote-unquote ADA website claims. So, and moreover, plaintiffs' lawyers can still send demand letters demanding that a website is not compliant with the ADA or some other anti-discrimination law. So, practically, we know that in many courts, still in the U.S., state and federal courts, that these type of claims can be made. But who can they be made against? And this is where the every website becomes involved. So on the new ADA.gov, it states that under Title III, businesses, including nonprofits that serve the public, fall under Title III. And then it says these are known as public accommodations. Okay, and then it lists some examples of public accommodations. But now let's look at the ADA itself. And the general rule is no individual shall be discriminated against on the basis of disability in the full and equal enjoyment of the goods, services, facilities, privileges, advantages, or accommodations of any place of public accommodation. And then if we look to the Americans with Disabilities Act, ADA Title III Technical Assistance Manual covering public accommodations and commercial facilities, it states that in order to be considered a public accommodation with Title III obligations, an entity must be private and it must own, lease to, or operate a place of public accommodation. What is a place of public accommodation? A place of public accommodation is a facility whose operations affect commerce and fall within at least one of the 12 following categories. And then it lists off 12 categories. Here are some. 1, places of lodging. 2, establishments serving food or drink. 3, places of exhibition or entertainment. 4, places of public gathering. 5, sales or rental establishments, and so on. And then the document says, can a facility be considered a place of public accommodation if it does not fall under one of these 12 categories? No. The 12 categories are an exhaustive list. However, within each category, the examples given are just illustrations. For example, the category sales or rental establishments would include many facilities other than those specifically listed. So, technically, your business may not fall under one of these 12 categories. And in that case, the ADA wouldn't apply to you. But practically, it's really the plaintiffs' law firms that are enforcing and or testing to see whether or not the ADA is applied, because plaintiffs' law firms, they don't mind initiating litigation because there's an asymmetry that exists. There's not much downside for them in filing a complaint or sending a demand letter because they have the infrastructure built in for litigation. However, for entities that aren't that don't deal in the law, that aren't regularly in court, so anyone other than a law firm, it's a huge cost, and it requires a lot of resources, and there's a lot of energy in deciding how to respond to it, whether to respond to it, etc. So the practical answer is, I recommend that all businesses make their website accessible, and I should say all entities, whether you're a nonprofit, whether you are a business, whether or not you think you fall into one of these 12 categories. It's better to err on the side of accessibility, because not only would you take care of any potential compliance issues, but you would also make your website more accessible to a broader audience. So does the Americans with Disabilities Act apply to every website? No. But for the reasons I've discussed in this video, I recommend every website make their website, every business, every organization, every entity make their website accessible.